We're going to get started here. My name is Dave Gelfand. I'm a professor of practice. I work in Washington, D.C. I teach in Washington, D.C. for ASU. And it's a real pleasure for me to be part of this conference. Thank you, Gary, for inviting me and for allowing us to put together this amazing panel with the folks we have assembled. My focus is antitrust. For most of my career, I've been a practicing antitrust lawyer. I've represented tech companies. I've represented all kinds of companies. I've spent time in government. I've spent time in private practice, mostly in private practice. And the focus of this panel will be antitrust and competition and regulation that is adjacent to antitrust and places where antitrust doesn't really rise to the occasion. And as an antitrust lawyer, I think of markets as the solution to most problems. They allocate resources, they create pressure for companies to build better products, to create better services, and it's usually the solution to how we get to where we want to go. And that includes in technology, competition and innovation and entrepreneurship and the fear of failure have all resulted in amazing products and services that have been offered by the biggest tech companies and a lot of small tech companies. And there's a real debate going on right now, and I'm hoping that it will play out here because you have people here on the panel that come at this from very different perspectives, some from a very enforcement-oriented perspective and some from a very markets-oriented perspective. And I'm hoping we can generate some debate about this. But the question is whether markets are sufficient, whether we're safe from the things that markets create, whether there are problems with allowing the markets to lead to the right outcomes, and where antitrust and regulation ought to come in and rein in tech companies, and especially big tech companies. We usually think of this as a problem related to Google and Facebook and Amazon and Apple, Microsoft, but it goes much broader than that because technology exists in every facet of our lives. And so the way we're going to organize this today is we're going to ask each panelist to speak for maybe 15 minutes, 10 to 15 minutes. I would encourage the audience to ask questions. I want everybody to be engaged and have an opportunity to ask these folks whatever you want to ask them. So feel free to raise your hand after a particular speaker goes, and we'll take questions as we go. But we'll certainly do questions after they've each spoken as well. So here's who we've got. Gene Kimmelman, who I've known for a long time and think the world of, currently senior fellow at Harvard Kennedy School and Yale's Tobin Economic Policy Center. For the first 18 months of the Biden administration, Gene was the Deputy Associate Attorney General overseeing the Antitrust Division. He has served as Chief Counsel for Competition Policy in the Antitrust Division during the first term of the Obama administration. Gene has had a long and distinguished career advocating for consumer interests and addressing some of the most important issues of our time, ranging from the breakup of AT&T as a young lawyer to media consolidation and tech company regulation in more recent years. I learned last night at dinner that Gene has testified more than 200 times before Congress, which is really impressive and speaks volumes about the important role he has played during his distinguished career in impacting public policy and the way we think about these issues. Gus Hurwitz is the law professor and founding director of the Governance and Technology Center at the University of Nebraska, as well as director of law and economics programs at the International Center for Law and Economics. His work draws on his background in law, economics, and computer science to study how technology affects society and how society responds to those changes. He started his legal career at the Department of Justice Antitrust Division, and prior to law school was a computer scientist working on high-speed networking for supercomputer applications, for which his work was recognized by, of all places, the Guinness Book of World Records. I just never thought I'd have a panel that included a Guinness Book of World Records holder, as well as somebody who's testified 200 times to Congress, but this is really cool. Kathy Bradish, I've also known and worked with for a long time. We worked in the same law firm together for many years. We worked at the Justice Department together, and she is awesome. And she is currently the Vice President of Legal Advocacy for the American Antitrust Institute, a position she has held since December of 2022. For those who don't know, the American Antitrust Institute is an advocacy group that pushes for stronger antitrust enforcement. And they're one of the leading groups that speaks for that issue. Kathy has been an antitrust lawyer in both private practice and government from 2015 to 2018. She was Assistant Chief and International Counsel at the U.S. Department of Justice Antitrust Division, where she represented the division's views on antitrust enforcement abroad and advised case teams on issues affecting cooperation with foreign antitrust enforcers, as well as provided guidance to leadership on competition issues arising abroad and affecting the United States. Kathy led the negotiations of competition chapters in the U.S.-Mexico-Canada Agreement and in the Transatlantic Trade and Investment Partnership. Jennifer Huddleston is a Technology Policy Research Fellow at the Cato Institute. Her research focuses on the intersection of emerging technology and law, with a particular interest in the interactions between technology and the administrative state. Jennifer's work covers topics including online content moderation, antitrust, data privacy, judicial deference, liability protection for internet platforms, autonomous vehicles, and other disruptive technologies. Jennifer is also an adjunct professor at George Mason University's Antonin Scalia Law School. So I'm very grateful that all four of these folks have traveled to here and given their time to us. I'd like to ask everybody to give them a round of applause even before they start. That'll get them fired up. All right, we're going to kick it off with Gene.
Okay, thank you, Dave. Thank you, Gary, for the invitation, to ASU for having us. And listening to all the great presentations today about AI, the wonders, some of the spookiness, some of the concerns, seems like the theme has always come back to, but no one's going to pass a law or do something about this. I thought Gary summed it up beautifully this morning as to what the practical path is. If you think there's going to be an agency, don't hold your breath. It's not going to happen. It's not realistic. What we need to do is use soft law tools, norm development, adjacent to agency-specific actions that are sector-specific agencies that can deal with some AI issues, adjacent to maybe something general from the Federal Trade Commission that is more what you can do under unfair and deceptiveness jurisdiction, and liability law. And that combination somehow together, back and forth, should get you somewhere. And I'm going to take the bold step of saying, yes, that's all true, but I'm going to predict in 5 to 10 years we are going to have an entity with broad oversight authority over companies like Google, Meta, Apple, Amazon, Microsoft. Those companies, maybe others that are just like it. And here's why I want to quickly frame this for you as to why I think we get to that point in this country. And a lot of it has to do with competition policy, but not all of it. I think what we're seeing is the attributes of the dominant digital platforms lead to markets that are few players. Before you get to whether there's bad behavior, illegal behavior, the nature of the network effects around digital platform markets, the ability to attract large customer bases, hold large customer bases, develop services using the data from all of the practices on the platforms, will create an environment in which you're very likely to only have few players, regardless of what you do. But at the same time, you have enormous powerful interests that are complaining about it. So this isn't the consumer market of doubling the price of widgets in most instances. It's the market of publishers feeling like their entire enterprises have been undermined through the online distribution system, advertisers complaining, small businesses complaining about the marketplace platforms that are now being driven more and more with a large role from Amazon. App developers yelling and screaming about the exorbitant pricing of apps in the Apple App Store in Google's Play Store, wanting separate payment systems, wanting to be able to load the apps that they want in the way they want to use them. A lot of really important commercial entities right in the forefront. And right behind them, I believe, are pretty much the dominant players in every other sector of the economy that are being disintermediated by the growth of dominant internet platforms, whether it's the automotive industry, it's the media industry, it's the telecom industry. They're all sitting there saying something needs to be done in their own quiet but powerful way. So there's enormous forces at play here to do something. And if you haven't noticed, just about every lawsuit imaginable under antitrust law has been filed or is in the process of being filed, either by private parties, the US government, but more importantly, the Europeans. Every one of these companies that we just mentioned are under litigation from one end of the world to the other, and this is ongoing. But even with that, even if I were to predict that most of those cases are a success, I'm still going to land where I said I started here, that there will be some entity with oversight, with new authority over these companies, for a number of very simple reasons. One is the cases take forever. Even if you're successful, you're often litigating things that were they're fact-specific litigations. You're often litigating about things that happened 3, 4, 5, or 10 years ago, and we're seeing some of that play out. So the process is unbelievably slow. The judiciary is, we say, not receptive to all the theories that are being put forward, particularly in this country. And so these cases are going to be not just long, they're going to be very hard, and they're going to be picked apart. And so it's very unclear how that will play out, but most importantly, it'll play out to what the remedies are. Because if everyone thinks that even in winning these cases, it's going to fundamentally change the structure of the markets around the dominant tech platforms, I think that's very unrealistic. I think remedies are going to be narrowly tailored to the particular harms that they're actually found to have involve law violations. And I don't think you're going to get major restructuring. And the biggest evidence for why this will then lead to a very unsatisfactory feeling is what we've just seen happen in Europe. And while we've talked about a lot of things today and mention has been made of Europe, I want to now just spend a few minutes talking about Europe, because I think Europe is the de facto regulator of the tech sector at the moment and will be for the foreseeable future. And that will drive things. The Digital Markets Act, which will take effect within a year, has a number of very specific obligations and duties. So, just to mention a few, indexing and ranking for search can no longer be preferenced by companies like Google. Can't do it. It's a prohibition. There's no defenses. They're not allowed to. Data that is generated around advertising on display advertising platforms for publishers and for advertisers has to be made available to those entities. All of their own data, all data relevant to their own queries related to ad placement and ad pricing. Period. No defenses. App developers get to build their own payment systems, and they get to sideload apps into the App Store for Google and for Facebook. Data cannot be shared across services by the dominant platforms for their core platform services. Maps, Chrome, Play, can't share. Yeah, you could get permission And maybe that's what will happen ultimately from users. But there are a whole, and there's just a slew of these, just obligations and duties. The UK is now in the process of passing a similar law that will have defenses, but actually has even a broader scope of potential interventions along all of the same lines I just described. So I believe this is what will drive changes in business models for the dominant platforms in the next 3 or 4 years. I don't think any of them can and would even want to try to survive without participating in the European market and the UK. So that's where the ballgame will really be played. And the issues that are adjacent to antitrust, that really are the ones I think that affect more consumers directly, are things like psychological harms of online use, whether it's kids or just general addiction concerns, or how we're spending 8 hours a day in front of a screen and time keeps growing and growing. It's things about concerns about disinformation. It's concerns about privacy or data use or how we can get a hold of how we're being profiled and our information's being used. And there's a lot of concern derivatively from the kind of companies I mentioned before. People want their small distributors in their community to survive. They don't want it to be all Amazon, even though they love Amazon. They don't want it to be all Amazon. So a lot of the concerns about small players reverberate back to consumers as well. But a lot of their issues are clearly not antitrust issues. They're adjacent to it. They're somewhat different. And someone in government is going to need to deal with that. So I think that when you put all this together, it is very likely that what comes out of Europe will require a US response. So yes, in the short term, a couple years, maybe not much happens, but I really think it will happen here. And I think the real challenge is, what's the US version? What's the American version of something like the Digital Markets Act, the Digital Services Act, or the UK regime? What's our way of doing this that matches up, but maybe is the unique American flavor? And I'm even willing to predict that most of the large companies that are fighting like crazy the implementation of these new laws will be one of the driving forces for harmonizing all this across global regulation, because they're not going to want to have different business models in different parts of the world. So that's my story. Thanks.
Questions for Jean before we move on to Gus? Yes.
So I couldn't tell whether what you're saying is mostly descriptive or sort of normative, but maybe you can sort of tease that out with my answer to this question. I don't see Europe as a model because I think there's this clear collision course between GDPR and the DMA. I mean, even some of the examples you gave, you have to give all the behavioral advertising data to another company, and yet you also can't. You know, and so I see Europe as like going as a model of a giant mess, potentially. So are you saying that we will kind of model that mess, and that's good, or anyway?
I'm saying that there are, what is most unique about the Digital Markets Act, and it tries to factor in its own conflicts with GDPR in doing that. Again, you could say it doesn't do it well or not, but it has very specific mandates. So let's just take the worst case scenario. It's a mess. What
Hey,
happens?
Jean, just for those who don't know what GDPR is, could you describe it?
Was the general, you know, the General Data Protection Regulation. It's the privacy regime for Europe. Let's just say it's a mess. Europe is passing an AI Act. Europe is passing a new Consumer Protection Act. All of these things overlap. Whatever the mess is, there will be a next phase of regulation. And whatever, if you think that'll be a mess, that will be then leading to the next phase. I do not think Europe is turning back. I think they have dug in after having litigated many antitrust cases, and there will be many more to come. They're still doing antitrust. They're not giving up. I think we are on the path to a set of deeper and deeper regulations. And I think actually the companies will find it in their own interest to help Europe figure out some equilibrium because they're not going to want to have to keep changing everything every year and playing cat and mouse forever. So I think that's the way it goes. And I think it will, and I do think there will be a lot of companies that will benefit from some of the things Europe does, even if it's a messy process. When there are multiple ways of loading your apps in and around app stores, if there are multiple payment systems, you're going to have some companies who are going to want to do their business in Europe and not in the U.S. if the U.S. hasn't adopted that model. Not everything will go one way. It's going to be two ways. There'll be innovations maybe in the U.S. market that Europe won't get. But Europe's reaction to that will be to regulate more, not less. That's what I'm basically saying.
All right, thanks for the question. One more?
I'm curious about what you think of the approval of European Union for the Microsoft acquisition of Activision, whereas Britain and the U.S. are opposed to that. So it's, I mean, I have to agree with your position that Europe tends to be our regulatory dominator here for tech, but this is just the opposite. How did that happen?
Well, I mean, others may have much deeper knowledge of this. I actually think that what just happened in Europe is an indication of what I was just describing. I think that the Europeans are getting more and more comfortable with the fact that they're going to use the DMA and less of their antitrust laws to try to restructure things within the business models of the dominant firms. They found that to be not very satisfactory in the past and way too slow. And they don't use a breakup model very often in general in Europe. So I think what they've just accepted as conditions on the Microsoft deal fit very perfectly within the DMA model. And in fact, while it's not part of the decision, the last thing I mentioned, the opening up of app stores to sideloading and to payment systems, one of the biggest beneficiaries of that would probably be Microsoft. There are others in the market now, but Microsoft, if they get bigger in gaming, is much more likely to grow there. So I think Europe is just moving down a different path of how to change dynamics in the market. Now, what ends up happening with whether that deal ultimately is consummated is a really interesting question. I think unless the parties walk away from it, they'll probably litigate in the U.S., and I don't know if they can litigate or function around the UK blockage, but I'm sure that, others may have different views.
Thanks for the question. Gus?
Okay, so I have to start, so many things I have to start with. I'll start by thanking Gary, of course. Wonderful to be here, and thanks, Gene, for your comments, many of which I will agree with, many of which I will disagree with, many of which I will be ambiguous about, because that's a way to prompt competition and discussion. We'll start by agreeing with the outcome and reflecting in so doing on many of the framing discussion and remarks for the conference, which is I very much prefer and believe in a soft law, self-regulatory, trust-based approach to these issues. In order for that to be successful, these firms, these industries have to establish and maintain trust. And I've said before, I'll say again, I'm certain at events like this, with friends like these, who needs regulators? Boy, oh boy, this industry really wants to be regulated, even if it doesn't. So I agree that regulation is very likely in the offing. Now, the question is, I guess whether, why, who, and how. And I'll also just say bringing the EU dynamic into this makes it so much more complicated. One additional element to add in, building on what Jane mentioned, is Privacy Shield, which it's entirely likely that U.S. firms won't be allowed to do business in the European Union pretty soon. So that might take that whole set of issues off the table for us, because boy, oh boy, it's just crazy. And for that matter, a lot of U.S. tech firms might not want to do business in Utah pretty soon. So this is just a complex area. But whether and why, I'm going to start a little bit why and whether. I don't know why we're going to do this, because we decide to as a country, as a polity. More seriously, it's hard to figure out how to regulate emerging technologies. Hey, look, we have a whole conference about this. It's been running for a decade. This panel is very much oriented around antitrust, and I'll bring in consumer protection law, FTC, Federal Trade Commission in particular. And why is that? It's because antitrust and consumer protection law have these very broad, ambiguous authorities, and when we can't figure out what the regulatory framework is for something like AI, oh, well, we can just say it's competition, you're really big, we're going to bring in regulatory authority here, or consumers don't understand this, it's unfair to them or it's deceiving them. Very broad, ambiguous general authority. So at some level, these areas are a great opportunity for us to address real problems while short-circuiting all the hard work that you actually need to do to figure out how to regulate emerging technologies. Now, I'm generally pretty skeptical of this sort of regulation. I think it tends to be responding to the last generation set of concerns, not keeping up with the technological frontier. It's subject to easy capture. Hey, look, OpenAI wants to help Congress figure out how to regulate all of OpenAI's emerging competitors. That's a surprise. It creates barriers to entry and innovation. But look, I'm just a guy sitting in front of an audience, keenly aware that regulators are going to regulate and polities are going to politic. If we don't trust these industries, if we don't trust these firms, guess what we're going to do? We're going to regulate them. Politicians are going to promise regulation. They're going to appoint regulators to head the agencies who are going to take advantage of broad, flexible legislative mandates to do stuff. Maybe good stuff, maybe bad stuff. I am not opposed to the idea that these firms need to, in some cases, be regulated. And in fact, some rules for the ground, rules for the road can be great for industry, for innovators, for consumers, for the economy. The question really that I'm more interested in isn't the whether or the why, but the how and the who. And my general concern and perspective on this, I've got a substantive antitrust law point to make, since as Gene said, points to all of these antitrust cases. The Federal Trade Commission is currently the de facto regulator for many of these areas. I expect that 10 years from now, when we do have a new regulator, it's not going to be a new regulator. It's going to be the Federal Trade Commission given new authorities. It's not going to be the federal AI regulation or the NTAI. That's a joke for folks who know that NTIA is an agency. Yeah, antitrust law, great for jokes. But the antitrust message that I have is, please don't break antitrust law. Antitrust law, the consumer welfare standard, they're really good at doing a set of issues really well, addressing a set of bad actors, helping with a set of problems. Let's not break them. Let's not throw that baby out with the bathwater, going after the emerging technologies. I've got substantive reasons for that. I think that antitrust law is great. I don't want it to be broken. But we also have, sorry guys, administrative law reasons for this, administrative state reasons for this. The last concurrent session that I was in, Kenneth Anderson, I don't know if he was here, he started by making, at some point during his discussion, he made the point that at events like this, we're really good at talking a whole lot about how do we regulate these things? What is the mechanism for regulating emerging technologies? And we kind of skip over the boring regulation topics of what is the law, what is the Administrative Procedure Act, what is the regulatory edifice that governs the administrative state. And we need to pay attention to that. We especially need to pay attention to that today, because over the last 10 years or so, the Supreme Court has been very actively reining in the administrative state. Over the prior generation or so, we built up this very deferential body of precedent, cases like Chevron, the Chevron doctrine and all of that. And it's broader, this is broader than just Chevron. But over the last decade, and this is absolutely going to continue for years to come, the court has been saying, hey, agencies, we've got concerns about your constitutional structure. We've got concerns about accountability of agency heads. We're going to start saying things like the CFPB's structure is unconstitutional. We're going to start saying things like the SEC and the FTC's longstanding use of disgorgement to go after monetary remedies as equitable relief. That's not clearly authorized by Congress, so guess what, guys? You can't do that anymore until Congress says that you can do this. Things like the major questions doctrine. This is probably the biggest issue right now as a constraint on agency deference, especially when doing things like interpreting ambiguous grants of broad authority to do really big things like transform antitrust law into a general purpose tool for regulating the tech industry. So the big message, the big concern that I have for the agencies is be modest, because we are in a state today, we're in a time today where if the courts feel like you, a federal agency, are pushing beyond the law, the outer boundaries of the authority that Congress has given you, they're going to say no. You need to go back to Congress to do this. So if the FTC is going to be this regulator, if they try to do it without clear congressional authority, they're not going to be able to do it at all, and it could cost them legitimacy in the eyes of the courts, ultimately limiting their ability to do other good, important stuff that we need them to be doing. Ultimately, this authority needs to come from Congress. I kept that to under 10 minutes.
That's beautifully done. Any questions for Gus? I think I have one, which maybe Gene and Gus, you can both try your hand at, since you've kicked us off on this issue of whether there will or should or who will be the regulator. What is the evidence on whether there's a problem? We seem to take it for granted that there is a problem. What is the evidence that consumers have been harmed by big tech? We know that they've innovated a lot. We know that they give their services away for free to consumers. We know they've made advertising a lot more effective. What's the problem? Do we just not like big companies? Is there evidence of actual consumer harm? What is it that we need the regulation for? I guess that's the question I would ask, which maybe Gene is going to be a little more pushback on that, but I think I had a willing recipient of the question.
Let's start and Gene, see where we go with this. I, unsurprisingly, perhaps am generally of the view that big tech is great. I think that there's been a lot of consumer welfare, a lot of benefits in traditional economic sense. I'm a dynamic competition kind of guy. Sure, lots of old industries have been harmed, but they've been replaced by newer industries. And every time that we confront the gales of creative construction, we have these concerns. And this is a generational sort of concern. So a lot of the big tech side of the concerns, I'm not that sympathetic to. At the same time, we are seeing changes in society, and one of the points that I make frequently when talking to economist friends who are very pro-innovation, pro-big tech, this is all great, is S-curves bend twice. And we're still on the upward swing of the S-curve, I believe, where things are getting better and they're creating more value and wealth and making us all better off. But at some point, we go from innovating to consuming that prior innovation in a period of stabilization where we actually do need to slow down. So that's a hard theoretical question. The other area where I'd say, and we've been talking about this several of the sessions as well, and we're all generally aware of this, technology is changing human interaction with each other and social dynamics, and a lot of, I think, very legitimate concerns about its impact on children and psychological development and the like. And those are really hard questions. I don't think that they are antitrust questions or consumer, at some level they're consumer protection questions, but I think that there will be social change to address these concerns that might come just through, hey, 5 years from now, we as a society have figured out how to incorporate technology into children's upbringing in a better, healthier way. It might be self-regulation. It might be that industry has figured out how to do this. It might be that I'm a big fan of sci-fi and Dune. It might be that we've had the Butlerian Jihad and we have outlawed all thinking machines because they're too dangerous, and we prefer to go back to a mechanical age.
I have no idea what you just said.
Okay, well, humanity declares war against the thinking machines because they're too dangerous. A sci-fi trope, but also, you know, if as a society we decide that's the direction that we want to go, I accept the democratic legitimacy of really bad decisions.
That's funny. Gene, what's the evidence? What's the evidence we even need this regulation?
Well, so I'll just start off with, there are areas I can't talk about because having been in the Justice Department, there are things I can't talk about anything that's under enforcement. But let's just say for a minute that the government and any of the private parties win any of the antitrust cases. If they win them and they're sustained on appeal, it will be a demonstration of consumer harm. It'll be a demonstration of supply constraints, somehow limiting.
If the government wins.
Yeah, if the government wins.
Got it.
If the government wins against the companies, there will be demonstrations of either loss of innovation. It'll be a little bit like the Microsoft case. That one was not, that precise about what wasn't in the market, but it'll be the general theory that the practices that constrained smaller or other players harmed innovation and choice, I think. On the broader question of regulation, that's why I named all the other kind of players who are out there griping. I think that's what drives the policy debate. It's publishers, it's advertisers, it's app developers, and a variety of others. Everyone who's in the specialized search business, whether it's the travel agents and the online hotel booking, anybody who's trying to do content work and goes through the internet has seen massive changes from the old brick and mortar world to the world today. Now you can say that's life, that's innovation, that's the way things change, or you can go to Congress and say something's wrong and we need smaller businesses, we need more players, we need more choice. I think that's what's going to drive the regulatory fight. And if you look again at what the UK and the European Union did, the European Union, the framing of the Digital Markets Act is predominantly around business users, not consumers, business users who are not getting full value for what they have contributed towards X, whatever the platform service is. Some notion of exploitation or not being able to reap their just rewards for participating in that platform distribution model. And so that's the concept they've used. And the UK law is a law that includes consumer protection meshed together, as Gus has described. So it's designed to actually serve two purposes: gaps between antitrust and other competitive concerns and consumer protection. So I think that's the driving impetus in one form or another.
Thank you.
I'll very briefly, and then we should bring Kathleen and Jennifer into the discussion, just say the digital economy is so much more complicated than the 20th century industry was. Understanding how companies can harm and benefit from each other and how they affect consumers, the concepts of joint and co-production, and how that affects the allocation and extraction of rents is so much more complicated than it was 100 years ago or even 50 years ago. And that's a real challenge for antitrust law and regulators to figure out.
I guess the question is whether when something's complicated, do you let markets figure it out or do you let regulators figure it out? But let's go to Kathy. And Kathy, I know you're going to talk about some of the recent enforcement actions maybe you can give us some predictions about whether the government is going to win some of these cases, as Jean has indicated they might.
So the theme of my presentation will be playing off of what Gus was talking about, that even if the FTC and DOJ are modest, courts may still say no. So what we've talked about so far are what new regimes might exist in 5 years or 10 years or 2 years from now. What I'm going to do is turn the clock back a little bit and take a look at what legal frameworks we have today, what the antitrust agencies are doing with those frameworks, and what the courts may make of that. So as many of you may be aware, the DOJ and the FTC are two U.S. antitrust agencies. Both have actions pending in federal courts right now targeting the conduct of big tech for violations of our monopolization laws, which we antitrust folks call Section 2. So I'll probably do that during this. I should note I have no inside information about these actions, and everything I talk about today is based on public information, and I will probably make Jean wince when I describe some of these things.
He's not allowed to wince publicly, though.
So also in the interest of time, I will talk in detail about only 2 of these actions. But I think they're representative of several actions that are ongoing, including private plaintiff actions, and importantly, really quite importantly at this point, the state AG actions. And I'll also note that I think this is a very pivotal time for the future of enforcement actions under our legal framework and against tech in the courts. Some cases are approaching trial very shortly. Others are being tested at the summary judgment stage, and still others are facing motions to dismiss, as well as a variety of discovery disputes, which will make a difference. So if we were to talk about this in a year from now, our discussion might be very different. The legal landscape might be very different based on how this plays out over the next year to 2 years. So on the DOJ side, the target is Google. The antitrust division has not just one case against Google, but 2 active cases against Google. The first of these, which I'm going to focus on today, dates from before the time that the current administration was actually fully in place, and really started to take form under the previous administration, which may be a great illustration of the fact that the desire to rein in tech may be the only thing that our political parties can agree on today. So this case is focused on the search market. And in particular, it's looking at the contracts that Google has with various third parties, Apple, for example, OEM, original equipment manufacturers like Samsung, and browsers like Mozilla. These contracts govern the terms under which Google basically is, I'm oversimplifying, but is pre-installed on these, on your phone and your computer. The DOJ alleges that these contracts, which provide considerable benefits, including revenue sharing in some cases, to the OEMs and other third parties in exchange for priority placement, for example, as the default search engine, that these contracts have worked to exclude other search engines and essentially take the air out of the room that would perhaps give rise to competition. So the summary judgment is pending in the case, so we'll see relatively soon whether Judge Mehta in the District Court for DC will allow this case to go to trial. And this will be extremely important. So I will also add that the state AGs have a parallel complaint, but they also have added some very interesting allegations about how Google's advertising optimization tool and its relationships with the specialized vertical providers, essentially the specialized search engines like TripAdvisor, may have further blocked the path for competitors in search. So to understand where this case is, we need to know a little bit about antitrust law. Section 2 requires two things, monopoly power and exclusionary conduct. And like all this is probably antitrust 101, but like all rule of reason cases in antitrust, there's a burden shifting framework. Plaintiff has the burden of showing that there's an anti-competitive effect. Then defendant has the burden of showing a pro-competitive benefit. And then it goes back to the plaintiff to show that the antitrust effect outweighs the pro-competitive benefit. At summary judgment, Google is not contesting monopoly power. Instead, what they're focusing on is asking the court to find as a matter of law that DOJ cannot show that Google's contracts have an anti-competitive effect, essentially the first step of the burden shifting. In a nutshell, Google is saying these contracts aren't really exclusive, and that DOJ really can't show that the market has been foreclosed. Exclusionary contracts, of course, are a fairly common part of Section 2 enforcement, but these are a bit different than our normal contracts. The contracts don't demand that Google is the only search engine available, but that it's the default search engine. Google argues that, in this respect, that customers can easily switch from the default search engine, and in fact, its current market position reflects that consumers prefer Google. DOJ, in turn, argues that the default position creates significant switching costs, and many customers will never spend the time and energy to make a switch, regardless of their preference. And in fact, preferences today reflect previous monopolistic conduct that created feedback loops and network effects that created whatever customer preferences exist today. And by the way, DOJ argues that why would Google pay so much for this positioning if it didn't really matter to their market position?
How much did they pay, Kathy? Do you know?
I don't know the full number because there's also revenue sharing.
Okay.
So on the other side of Constitution Avenue, the FTC's target is Meta, formerly known as Facebook. Their amended complaint, it's their second complaint, and it looks a little different than their first complaint, argues that Meta violated Section 2 of the Sherman Act when it acquired Instagram in 2012 and WhatsApp in 2014. And the FTC argues that this effectively stomped out potential competitors before they could challenge Facebook's monopoly position at the time. The Judge Boasberg in the District Court of the District of Columbia sided with the FTC on the motion to dismiss. The judge looked to US versus Microsoft and said, this is a similar situation. In that case, the US v. Microsoft stood for the idea that while it was impossible for anyone to say for certain whether the nascent threats of Netscape, for example, would have grown into serious rivals to Microsoft, this was not fatal to plaintiff's claim, and that it reflects a judgment that, in some degree, the defendant is made to suffer the uncertain consequences of its own undesirable conduct. So if we don't know what's going to happen and there was bad actors, then we should at least give some space for that to be examined. So far, so good for the FTC. But then this case also has a parallel state case, and that has made its way to the DC Circuit because it was dismissed primarily on the ground of latches. They had waited too long to bring the case. While much of the decision is technical, the DC Circuit put, in my view, a bit of a bombshell in the last couple of pages of the opinion. First and most relevant to the FTC case, it directly questioned whether divestiture of Instagram and WhatsApp, which is what the FTC seeks as a remedy, is equitable given the amount of time that has passed since those acquisitions were made and the incorporation that has happened into the company. Second, and this has a bit of, not so much a direct effect on the FTC case, but on lots of tech cases, it affirmed dismissal of the state's claims that Facebook's policies on access to its platform that disadvantage competitors. It affirmed that those were dismissed on the grounds of Trinco, which I'll describe as a very broad reading of what kind of unilateral business conduct the courts say we should abstain from judging. So, and the language of the DC Circuit, I think, is particularly concerning. They wrote, "We note in particular that courts should proceed cautiously when asked to deem novel products or practices anti-competitive. Many innovations seem anti-competitive at first, but turn out to be the opposite. And the market often corrects even those that are anti-competitive." Similarly, if courts required firms to lend their facilities to competitors, courts would have to manage corporations' business affairs, a role for which the judiciary is ill-suited. In other words, to quote the speakers from our first plenary, the court seems to say not just that big tech is innocent until proven guilty, but that we're even hesitant to try to disentangle pro-competitive from anti-competitive in this space. I think of it as a sort of throwing up its hands. Well, this is so innovative, we're just not going to even touch it. And to have this kind of language come out of the court that created the model of challenging tech companies in US v. Microsoft, it's quite ominous. So what do both of these cases illustrate about the challenges of litigating Section 2 against big tech and where it might be going? First, there's divided case law in Section 2. Everyone knows Section 2 is notoriously difficult to litigate. Courts are dubious about punishing unilateral conduct. They're hesitant to second-guess business decisions and wary, in my view, excessively about chilling pro-competitive business practices. So this has led to a bit of a divided case law. On one hand, you have Section 2 case law that demands that you look at the conduct as a whole and the amplifying effects that one part of the conduct can have on another. And on the other, you have a kind of bucketing of the Section 2 conduct. And where there are discrete buckets of conduct, the course of conduct is broken up into these discrete buckets, like we give them a name: predatory pricing, refusals to deal, exclusionary contracts, and then we apply various demanding tests that have developed over time, essentially a bit of a checklist. Is there a prior voluntary course of dealing, for example, for refusal to deal? I think this is a particular problem where courts are nervous about understanding the technology and the path of innovation, because this checklist approach is easy in many ways. It seems cleaner, and at the extreme, though, the checklist that were really created in the context of other industries, not in the context of tech, may wind up making big tech conduct largely immune from antitrust enforcement. Second, anti-competitive effect. The courts often rely on the but-for world to demonstrate what would have happened if this anti-competitive conduct hadn't happened. So they often rely on that to demonstrate anti-competitive effect. But the nature of big tech can make that difficult. How do you show that Instagram would have challenged Facebook rather than pursuing its own differentiated path? How do we know what Google would look like if they had never acquired DoubleClick? But then the question is, do you need to have a but-for world? Or, as the court in US v. Microsoft formulated it, do you have a standard that says, is this conduct that's reasonably capable of having a significant effect, a significant contribution to maintaining monopoly? I think I got that right. And finally, remedy. And this is just the the fact that it can be difficult, as we saw with the DC Circuit opinion, to get a court to do what the agencies propose, because some of it is pretty extreme. In these cases, both of these cases, in this case and the other Google case, the remedy that the agencies are seeking is divestiture. And that is, of course, one of the most extreme remedies that we have in antitrust. And it's going to be a big pill for courts to swallow. So all in all, I would say there is a path to antitrust enforcement against big tech, but that path is narrow. And any adverse decisions in these upcoming cases could narrow that path really to a tightrope.
Thanks, Kathy. It's a great description. I should have asked you to note this earlier, but Section 2 that Kathy refers to is Section 2 of the Sherman Act, 15 U.S.C. Section 2. I know you could have figured that out from a Google search because Google is awesome, but that's the
What's
law.
Section 5 then?
And it was enacted in 1890, and after 133 years, we're still trying to figure out what it means. So lots of interesting work for antitrust lawyers there. Any questions for Kathy before we move on to Jennifer? All right. Jennifer, you've shown remarkable restraint. I know you're a champion of free markets, and you might not have agreed with everything you've heard so far. So thank you for that.
Thank you, and thank you, Gary, for having us, and David for moderating this panel. But David, I feel, forgive me, I am going to have to take issue particularly with one thing you just said. You said everyone would Google that. Surely you meant Yahoo it. And I apologize, but he also...
I was going to ask Jeeves it.
He also neglected to ask everyone to please silence your Nokia cell phones before this panel. And I assume that we have a hashtag for the MySpace related to this event. And all of these are easy to laugh at, but if we'd been having this exact same panel 10 to 15 years ago, those would have been the who that we were talking about. Those would have been the question of, is big tech too big? What are we going to do about the AOL Time Warner merger? What is going on with MySpace's natural monopoly? How Yahoo won the search wars, and that Nokia is in fact the cell phone king that will never be caught. But what we saw is that actually we have something even better when it comes to competition policy. And that is that oftentimes innovation is our best competition policy and is the most consumer-friendly competition policy. If all we're doing is looking for the next Google, the next Facebook, the next Yahoo, the next Nokia, we may miss what's actually going on in an incredibly dynamic way. I think we're having this conversation at a very unique moment, particularly when we talk about things like search, because we're seeing AI really revolutionize the way different processes work. I don't know how many of you happen to teach law school or university courses, but I taught a course last spring and I taught the same course this spring. And if you had told me last spring that this spring I would have to have an AI use policy for my exam, I probably would have laughed in your face. But that's the world we live in, where we never know what that next big disruptive innovation is truly going to be. I think there's another, though, who and what are we talking about in this conversation, which is we've seen, as was kind of alluded to earlier, this realignment when it comes to changes on calls for changes to antitrust standards or changes or more aggressive antitrust enforcement, in that this has become an issue both on certain portions of the right of center as well as the left of center. And a lot of that stems from the fact that we see people calling to use antitrust for things that it was not exactly designed for. Antitrust is designed to be competition policy, but yet we see calls to use antitrust for a range of tech policy issues, things like data privacy or online content moderation, that it's poorly designed for and that it could in fact make those same problems worse. At the same time, though, when it comes to these debates over those same issues, data privacy law or changes to laws like Section 230, we don't hear as much conversation about the impact that could have on the market dynamic. GDPR was mentioned earlier. When it comes to a regulatory regime like GDPR, it's the largest players who can afford to comply, and the smaller players are going to struggle with compliance. When it comes to things like Section 230, it helps create an even playing field for the smaller players who can't necessarily afford to have that big powered attorney on call the minute that a user does something that they had not planned on their platform. When it comes to the question of what's going on in competition policy, I think it's important that we ultimately focus on who's at the heart of competition policy, and that's the consumers. Now, the consumer welfare standard is well evolved enough to handle two-sided markets. It can handle different types of consumers. But I think it's important that when we hear people calling for changes to antitrust and competition, that we take a step back and ask, what does that actually mean for the world that we live in? What does that mean for the small business owner who now wants to open their own store and doesn't necessarily have the same accessibility of online platforms? What does that mean for the user who buys a new smartphone and now has to make an additional steps to set it up? What does that mean for the next wave of innovation as well when it comes to trying to get their products to the market? We heard Europe brought up earlier, and I have kind of a different take on what's going on in Europe, and that I think Europe's approach to kind of its aggressive pursuance of things like the DMA and actions against American companies are at heart a protectionist policy. They didn't build their own tech giants, in part because of regulation, and now they're looking for ways to ensure that they can have a different market despite what the consumers actually want. There's another thing we haven't heard much about yet that I think is an important part of this debate, and it's the question of mergers. While we've heard a little bit about this, oftentimes mergers are brought up in terms of antitrust and the idea of a kill zone. The question of maybe the big guys are okay, but it's the fact that this next generation, that's why we're not necessarily seeing innovation as competition policy. But yet the statistics haven't really proven that through largely. And when it comes to calls for bans on mergers or acquisitions, again, we have to consider not only what that means for the end user consumer, but what that means for players of all sizes, particularly those small businesses for whom this may be a desirable exit strategy. Are we going to have the government dictating to businesses how they must conclude their business? Yes, there are those wonderful startups that go on to become the big household names, they IPO, and we all are grateful for it. But there are many other more niche products that the way they're going to reach their market may be to be acquired. There are people who are best served to be serial entrepreneurs who don't want to spend their energy running the big Fortune 500 company, but have amazing creative ideas. If we see changes, if we see the shift to a guilty until proven innocent instead of an innocent until proven guilty model in the world of mergers and acquisitions, I think there are many concerns about what that means for the overall dynamics in our market. Finally, when it comes to kind of where is this going, I think we have to talk about what we're seeing more generally in the US regulatory approach when it comes to technology policy. While we've seen a lot of debates about antitrust in Congress, and last Congress particularly, we saw a number of bills proposed, and I'm happy to, in our Q&A, get into the impact that specific bills would have. We're seeing more regulatory action occur at particularly the agency level, specifically the FTC, and this is not only in the antitrust element, but also with regards to technology and policy that could impact competition more generally. We've seen this recently when it comes to the FTC's non-compete action or notice of proposed rulemaking, and we're seeing this in continued interaction with tech companies. So my final kind of point would be the question that lies at the heart of all these cases that was asked earlier. Is there a harm, and if so, where? But I would also raise another question. Oftentimes, I think these cases are really a question of market definition. And are we trying to so narrowly define the market that we're missing the broader innovation that may actually be our best competition policy and where the actual competitors are?
Thank you, Jennifer. Questions for Jennifer before we open it up generally to the panel? Please.
So I think a lot of the focus on the panel's discussion today has been on market cap, defining relevant marketplace for consumers, and the scope of consumer harm, which I think is good, but I haven't seen a lot of development in the scholarship
So that's a very cool question. So the reference to black box pricing algorithms is the idea that technology can start to make pricing decisions, and already is and has been for a long time. I mean, there's been revenue management in airlines, hotels, rental cars, any kind of company that's dynamically priced their products. They've been using these algorithms for decades, actually. And the question is this getting so good that the pricing algorithms, which are made commercially available, are in effect helping companies collude on their prices with each other, even though no human ever reaches a meeting of the minds with their competitors about how to price products. So that is a problem we haven't talked about. It's a very interesting question. Thoughts from the panel on that question? Do we need regulation? Are the antitrust laws currently capable of handling that problem?
I'm happy to offer some thoughts, and folks are looking at me as though I don't want to say anything, so please, you say anything. First, it's an important set of questions and issues, and by virtue of the fact that you're talking about it and noting it, we're talking and thinking, and I have zero doubt that folks at the FTC and Department of Justice are thinking about these as well. But the academic-y, pointy-haired meta point that I would make about it is we should approach these issues cautiously and but also seriously. So one of the things that Jennifer brought up, and we've also brought up in this discussion already, is privacy. And the evolution of how antitrust law has thought about privacy is really compelling and important to study. So if you go back 15, 20-ish years, the general antitrust approach to privacy was, oh, this is great. We're seeing zero-cost products, and antitrust law loves low prices and high output, so privacy isn't a concern. And then we started to get into more sophisticated thinking of, well, firms that have this information, they have these network effects, and they're dominating the markets, and maybe privacy is actually bad for consumers, and well, the way that privacy is being used, information is being used, is actually harmful to consumers. And wait, well, that's not any good. We should start thinking about breaking up the firms that have all this information, or forcing data sharing and interoperability mandates. And now we're starting to realize that, wait, so if we have companies that are large and they have this information, and we're saying they need to share that information to facilitate entry, now we have more consumer information being shared, which is actually a negative privacy value, and we're doing this in order to promote privacy. This is really complicated, and maybe privacy and antitrust are two orthogonal issues that we need to think about much, much more carefully. And that's going to be the lesson that plays out in almost all of these markets with almost all of these technologies. We need to understand their dynamics and understand how they play out carefully. It could turn out that greater information about apartment rental prices getting out into these black box algorithms benefits consumers in the long run. It turns out lots of information tends to promote efficient markets. If that's where we ultimately get to, that's good. If black box algorithms gathering up all this information only being used on the supply side of the markets allows for collusion, that's not good. But we don't want to regulate and prevent the use of these technologies at stage one, where it's being used on the supply side, if that's going to prevent them ultimately from being used on the demand side. It's a complex set of concerns. So absolutely, we should be concerned about, we should be looking to the enforcement agencies to investigate and look into how these systems work, and is there unchecked collusion, parallel or otherwise, or is there competition in how these systems are being developed in a way that they might ultimately benefit consumers?
Other thoughts on big tech making commercial decisions in all sorts of industries?
Well, on this black box algorithm question, first I have to admit, that when I was at DOJ, years ago now, at least 5 years ago, I was sent to Europe, and they were having, among other things, a big panel on algorithmic collusion. And I went, I wanted to be informed. I went to DOJ economists. I talked to them. I said, well, what should we be thinking about? They told me, forget it. It's never going to happen. It's years and years and years away from that being ever a possibility. So I confidently went to this meeting. Oh, this is years and years away. We shouldn't be focusing our energy on this. So that turned out to be wrong. So humility is good. But I think there is an easy answer in some respects. I mean, price fixing, an agreement to fix prices is illegal. And it may be just an evidentiary question rather than a question of whether the law is adequate to it. And a lot of what we've been talking about are evidentiary questions. So I think there may be an easy, at least from a legal perspective, the answer may be easy. The path to showing it may be difficult.
Let me come back to litigation and evidence, and also a point you made, Jennifer, about merger cases. So the current administration, for the last 3 years, has been saying antitrust needs to be blown up. It's been done wrong for decades, something that some of us who've been in the agencies during those decades take a little exception with. But basically, they've said we've got to do it a lot differently and a lot more aggressively. And I think probably nowhere is that more evident than in the area of mergers. And there have been a number of merger cases, and the agencies have largely failed. They've been losing these cases at trial at a rate that I don't think I've seen in the course of my career, and maybe that they've never lost cases before in the history of the agencies. So where does that leave us? Has the more aggressive enforcement of the Biden administration already proven itself to be a failure? Is it deterring deal making just because companies don't want to go through that ringer of having to litigate cases? Is it affecting big companies more than little companies, or vice versa? Are they going to start winning cases sometime soon? Anybody want to comment on the current administration's record with merger challenges?
So I'll start, and then I'm guessing some other people on the panel may have some thoughts or may not be allowed to say their thoughts depending on how this goes. I think you're right to point out, David, that there is an amazing losing streak going on right now. But beyond what's going on in the court, we also have to look at what's going on in an agency level, particularly at the FTC, with the changes it has made to long-stated policies, both around the merger guidelines as well as around the Section 5 statement, various...
Section 5 of the
FTC Act, not the other one. It's an antitrust panel. We have to clarify which one we're talking about, where you are seeing an agency that seems to have a significantly different point of view on what it believes the policy should be and how the law should reflect that versus what the courts are seeing. And so right now, I think we are still seeing the courts have a very consumer welfare focused approach to, at least in the US, to mergers and acquisitions. What makes this very interesting is some of these same mergers and acquisitions, as was mentioned earlier with, for example, Microsoft and Activision, are also under challenge in Europe. And if you have, say, a European or a UK agency block it, that could still impact the decision for these American companies. The chilling effect question, I think, is interesting because one of the great questions is we never know what we lost. We never really know until after the fact. There have been some statements around Microsoft's failure to truly enter the mobile market during the time period, in part because it was fighting antitrust case. Would that have changed the mobile market? Who knows? Was that the only reason they didn't do it? Who knows? But there's that question there. When it comes to big companies versus small companies, I think oftentimes we forget about the small companies and that side of mergers and acquisitions. That for many companies, this is something that they want. This is something they believe is beneficial. This is not just someone coming in and saying, give me. This is a business transaction and is typically a business decision that companies have thought through and that they feel is the right course of action.
Other thoughts? I see
I'm
Gene
good.
is wincing a little.
Yeah, sorry, Gene.
That's the theme.
I'm going to go for a real Donald Rumsfeld moment here. So you can clearly win by winning, and you can clearly lose by losing, but you can also lose by winning, and you can even win by losing.
Wow.
Yeah.
I think
So,
Donald
whoa.
Rumsfeld once
So,
said that.
yeah, so obviously winning and winning, that makes sense. Losing and losing, that makes sense. If you bring a lot of small cases and you only ever bring small cases, you can lose because you're setting the bar too low. So only taking the easy cases, that's not going to push the frontiers of law. And I've been saying for years that I think that the agencies should be bringing some more progressive cases because you need to figure out what precedent is. And if you only are relying on the accumulated body of knowledge that enforcers have and that lawyers at big fancy DC law firms have so that they know how to navigate things through the agencies, and it's not really the case law that provides guidance, well, actually that can be harmful to a lot of firms, business out there that doesn't understand that accumulative body of knowledge that the DC antitrust firms have. You can also win by losing cases. And I personally think this is a really problematic way to go about making precedent and developing the law, but I think that this might be something that the Lena Khans and Joe Cantors, the heads of the current FTC and DOJ, for those not enmeshed in the day-to-day of this, that they're thinking about. Let's bring aggressive cases, and if we lose, that shows that current antitrust law isn't up to the task and makes it easier for us to go to Congress and say, Congress, look, we keep losing and we're trying to do stuff that you think is important. You need to update the antitrust laws or you need to give us new authority. Now that comes at really great loss of credibility before the courts, before the bar, before industry. So that's a really costly and dangerous path to go down, but you can win by losing.
Somehow, anytime I've ever lost a case, I never felt like I could win by losing, but it's a good
So
point.
Dave, just, I can't talk about specific things except what has actually happened. So I want to do your batting averages a little over again. My recollection is in the merger area, Justice Department, after Europe cleared the merger of Aon, Willis Towers Watson, stepped in to sue to challenge, and the deal was abandoned. They sued to block the Penguin-Simon Schuster merger and succeeded in what was probably a little bit of an edgy case to go forward. And they lost a sugar merger case, and there's one that wasn't a merger, but it was an alliance, AA, JetBlue, American Airlines and JetBlue, that's still pending. So of the cases,
And they lost Booz Allen, and they lost United Change,
Yeah.
and they recently surrendered in the Assa Abloy case. And the FTC lost the...
surrender is, they took a settlement, which is what you were claiming they weren't doing before and should be doing more of. So, but again, I think Gus's main point is, I think scorecards are a little weird here anyway. But I'll just say that in my time in DOJ, what I can say is in the first 18 months, there were 4 challenges of civil mergers. And in my time in the Obama administration, we never had 4 challenges of civil mergers. So there was an uptick in activity. And I think, the batting average, at least the 4 that I was involved in, could still be 50-50. One's still pending.
Okay.
It also bears note that many of the cases that Gene just mentioned aren't what we would think of as big tech cases by any means. And the antitrust discussion that a lot of these big tech issues are part of is also a broader standalone antitrust competition. So I don't know which is the tail and which is the dog. Maybe these are both dogs that are happily running around each other. Maybe they're both tails wagging each other. But Gene makes a really important point by reminding us that the big tech antitrust discussion is part of a big antitrust discussion as well.
Great. More questions, please.
Yeah, thank you. Brent Score from the Data Center. So when the Amex case came down, I read it. It's often depicted as an anti-enforcement case. When I read it, it doesn't seem quite that clear cut. I mean, you got to look at both sides of the two-sided, multi-sided market, and it seems plausible to me. Often defense for social media, tech companies, social media, consumers get a lot of free services, but it does seem plausible up to Amex. You can kind of tally that up, and then you could tally out the other side of economic harm, and there could be a Section 1 issue. Am I misunderstanding that case? Have you seen plaintiffs or prosecutors work with Amex in that way? Thoughts for anyone?
All right, so the question is about the American Express case. There was a Supreme Court decision. That was actually a case that was tried when I was at the DOJ. The DOJ won. It was challenging American Express's restrictions on merchants that prohibited them from steering customers to lower cost credit cards that would have cost the merchant less money. That was a trial victory for the antitrust division. The Second Circuit reversed, and that went up to the Supreme Court, and the Supreme Court affirmed the Second Circuit and held that the district court had not properly taken into consideration the other side of the market that Amex played in, which was it didn't just charge merchants, but it also served consumers with credit card services and loyalty points and benefits that the consumers got. And the court basically said in a two-sided market, as you just described, the analysis has to take into consideration both sides of that. In fact, Justice Thomas's opinion, it didn't remand for further consideration or retrial, basically said the facts were insufficient. As I recall the case, you might remember better than me at the moment, they were so insufficient that judgment was entered for the defense.
So just to be clear, when you say that was a DOJ victory, you mean ultimately the DOJ lost?
Ultimately, that's right, good point. Okay, that was a win that became a loss. Wow, you're just blowing my mind, Gus. I don't know how to think about litigation anymore. Anyway, any comments from the panel on that decision and whether it's truly anti-enforcement and it obviously affects big tech because so much of big tech is two-sided platforms.
Anyone want to talk about Amex?
Well, I'll just say that it depends. But not necessarily going into a pro-enforcement, anti-enforcement, but it is a question that is very relevant to big tech. And there is an element of this in the recent Epic versus Apple decision in the Ninth Circuit. And I think what you see there is Amex doesn't do everything defense bar that you think it might do, that two-sided markets don't immunize a company from antitrust, potentially having antitrust violations. It depends on the circumstances of the market. So at least in the current state of the case law, there is certainly wanting to push this. There's a movement to push this to say two-sided markets, we're not gonna touch them. But there is also a effort to or at least give some contours to it that are pretty fact specific.
Thank you, Kathy.
I'll just add, I think this echoes the previous point that I made about the economics of these industries being so much more complicated. So first we should say a two-sided market, these are sometimes referred to as platforms. They're things where you have a market maker that brings together different groups of customers. So credit cards, you've got the credit card merchants, and you've got the companies accepting credit cards, and you've got consumers. Platforms bring together advertisers and consumers, or just all the different users of social media platforms. After the Amex decision, I wrote a weird little article that no one has ever read because it's too cleverly titled Non-Cartesian Antitrust. Generally in antitrust, we refer to horizontal and vertical issues, and these platforms, they're not really traditional horizontal or vertical issues. They're these weird sort of issues, and antitrust law has trouble dealing with them. And I think the Supreme Court, I personally like the Amex opinion. I'm one of about 3 people on the planet who likes the Amex opinion. But if you look at a market like credit cards, it's really easy to say, this looks a lot like horizontal collusion, price fixing. It should be harmful to consumers. That should be enough to get you into court. Amex kind of says, no, you need to also, at the same time, before discovery, when you just bring in the complaint, you also need to look at how it affects the merchant side of the market, and this is a much more complicated analysis. And it's kind of not a good way of doing the analysis. I get that, and I agree with that, but it's hard. It's a much more complicated sort of market than antitrust law was designed to deal with, and boy, oh boy, what's a guy to do?
And if I can just add to what Gus is saying, I think when it comes to these questions in the technology arena, that's where we see a lot of market definition debates on what would be the equivalent of the merchant side of the market, of what is the advertising market in this day and age. Is it search ads? Is it more general advertising? Because how you define these things are going to vary dramatically in the outcome that you have.
So I have 2 rules when I moderate a panel. One is I ask the panelists not to ever agree with each other because one of them's already made the point, no need to agree with it. And my other rule is when I'm the last panel before cocktail hour, I try to end a little early. I'm only giving you 3 minutes back, but I'm going to do that now. If you promise to give this group of folks a big round of applause. Thank you. Thank you. Thanks, everybody. Great job. Thanks, Jennifer. Really well done.
You're all invited to come upstairs to room 554.
Thanks a lot.
Oh, you're welcome.